Hey everyone, my name is Costas and welcome back to another episode of Legal Talk, where we provide general legal information for the everyday landlord. Today, we'll be going over some of the less commonly used end forms that are filed with the Landlord and Tenant Board, namely the N2, the N3, N6, N9, and N10. Let's get started with the N2. This is the Notice of Rent Increase form for units that are partially exempt. The rent increase guideline is partially exempt from tenants who live in certain rental units, such as nonprofit housing or social housing and care homes, which are considered to be special rental conditions. You as the landlord can increase the rent if at least 12 months have passed since the date of the last increase or since the tenant has moved into the rental unit. The rent can increase by any amount as long as the tenant is given 90-day notice from the landlord. This form is not commonly used since it is very specific to certain circumstances, but is comparable to the N1. Next is the N3 form, which is the notice to increase rent or charges for care services and meals. This form applies when your tenant is living in a care home unit. When the tenant moves into the unit, you must provide them with a care home information package, which basically outlines the details involving the care they will be receiving. If you have not provided them with a package, you cannot use an N3 form. Care services include healthcare services, rehabilitative or therapeutic services, and services that provide assistance with daily living. Do not mistake this form with the N1 if you are simply trying to increase the rent on the unit. The forms are different because the N1 is used for the standard rent increase on a rental unit, whereas the N3 is only for care home units. You must give the tenant 90 days notice prior to rent increase. You are not permitted to provide notice by simply pinning the notice on the door of the rental unit. You must physically give the document to the tenant for it to be considered proper notice. The same 90-day notice applies if you are increasing the cost of care services and/or meals, just like you would if increasing the rent. If you and the tenant agree to add a new care service and/or meal that's not currently being provided, no notice is required, and you do not have to wait 90 days before charging for this new care service or meal. Similarly, you don't have to give a notice or wait 90 days before charging for a new level of care service. For example, if you and the tenant agree to increase therapeutic care from 5 hours per week to 10 hours per week. Moving along to the N6. The N6 is used to give notice for ending a tenancy for illegal acts or misrepresenting income in a rent-geared income unit. Basically, this form is used when you believe that the tenant is engaging in illegal activity within the rental property or that they have misrepresented their income. There are 3 reasons that you are permitted to use an N6 form. Reason 1. The tenant or another occupant of the rental unit has committed an illegal act or is carrying on an illegal business at the residential complex involving the production of an illegal drug, trafficking an illegal drug, or possession of an illegal drug for the purposes of trafficking, or the tenant has permitted someone else to do so. Reason 2. The tenant or another occupant of the rental unit has committed an illegal act or is carrying on an illegal business at the rental unit, or the tenant has permitted someone else to do so. Reason 3. The tenant lives in a rent-geared income housing and has misrepresented their income or that of a family member who lives in the rental unit. The termination date will differ depending on the reasons you are giving the notice, 1, 2, or 3. For reason 1, you're required to give 10 days from the date you provided the tenant notice. Reason number 2 and 3. If this is the first notice to end the tenancy in the past 6 months, then the termination date is 20 days from the date of that notice. If it's the second notice in 6 months and the original notice had a 7-day correction period, the termination date must be at least 14 days from the date of that notice. Obviously, the N6 is only used in very niche situations. While chances are you may never have to evict a tenant due to their criminal activity, the LTB provides this route to pursue that event. Now, moving ahead to the N7. The N7 form is used to give notice to end your tenancy for causing serious problems in the rental unit or residential complex. There are 4 reasons that you would utilize this form. Reason number 1. The tenant, their guest, or another occupant of the rental unit has seriously impaired the safety of another person, and this event occurred in the residential complex. Reason number 2. The tenant, their guest, or another occupant of the rental unit has willfully damaged the rental unit or the residential complex. If you use reason 2, you must be able to prove the tenant or their guest deliberately caused the damage to the property. If you are not sure whether the tenant or guest caused the damage willfully, file an N5, as the N5 applies to damage that is caused either willfully or negligently. Reason number 3. The tenant, their guest, or another occupant of the rental unit has used the rental unit or the residential complex in a manner inconsistent with its use as residential premises, and this has caused or can be expected to cause serious damage. Reason number 4. You live in the same building as the tenant, and the tenant, their guest, or another occupant of this rental unit has substantially interfered with your reasonable enjoyment of the rental unit or another of your lawful rights, privileges, or interests. When filling out this form, you must provide in detail the damage caused to the unit in the blank space provided. As with all forms that would lead to an eviction, you must file an L2 along with this form. The L2 must be filed within 30 days of the termination date on the N7. Up next is the N9. The N9 is the tenant's notice to end the tenancy. For most kinds of tenancies, the termination date must be 60 days after the tenant gives the landlord notice. If the tenancy is weekly or daily tenancy, the tenant must give the landlord at least 28 days notice. You can end any kind of tenancy on any termination date if you give at least 10 days notice, provided that your landlord has given you notice to move out for reasons such as wanting to use the space for family or a caregiver, for something other than living space, and to make major repairs, renovate, or tear down your rental unit. As a tenant, it's very important that you give your landlord the notice on time. Even if it's 1 day late, your tenancy will not end on the termination date you chose, which will result in you still owing your landlord money. I just want to mention that the N9 is not really that uncommon, but it is a tenant form that your tenant may serve onto you under certain circumstances. The N10 is a form used for agreement to increase rent above the guideline. You as the landlord can file an N10 if you have already completed or are planning to do extensive renovations or have provided or will provide additional services. Basically, there must be a reason as to why you as the landlord are raising the rent past the guideline by providing some form of benefit to the tenant. The key wording in this form must highlight a benefit to the tenant. You cannot simply renovate a part of the building, then charge increased rent to cover the costs. The new renovations or work must be accessible and beneficial to the tenant. For example, it would be acceptable to use an N10 if the landlord decided to create a new common area in the building for the tenants to play games, relax, etc. They would be able to use the N10 as it would provide value to the tenants. However, if the landlord decides to use an N10 to cover costs of a renovation to their own living unit within the building, that would not be permitted, as the tenants wouldn't have access to the new renovation. This form replaces the notice to increase rent form N1 if it's signed by both the landlord and the tenant. Note, the rent increase cannot be any more than the prescribed rent increase in the RTA plus 3%. You will also need to provide detailed information regarding the work or improvements to the property on the form. The date of the increase must be at least 6 days after the date the agreement is signed. All right, everyone, I hope this was helpful. Please remember, the information I am sharing with you is provided as a general overview. I highly recommend consulting with a legal professional to seek advice on your individual situation. As always, if you have found this video helpful or informative, please make sure to like this video, subscribe to our channel, and visit our website for consultation services so you can learn how to become a professional landlord. See you on the next one.